Congress unanimously passed the International Religious Freedom Act in 1998. The 98-0 vote in this body for that legislation, including 19 senators still serving today, 11 Republicans and 8 Democrats. We asserted that religious freedom, quote, undergirds the very origin and existence of the United States, unquote. And yet, religious freedom today is under attack across the country. Political activists are attacking religious freedom as the enemy of equality, claiming that laws protecting religious freedom are designed to enshrine discrimination in state law. This effort is misinformed, it's misguided, and it's misleading. It will serve only to harm religious freedom and to demonize religious people, many of whom would be allies in the effort to promote equality. The attack on religious freedom misunderstands the history and importance of religious freedom in America. That story began more than 400 years ago as one religious community after another came to these shores so that they could freely live their faith. As far back as December 1657, residents of the community known today as Flushing, New York, signed a petition called the Flushing Remonstrance. This petition protested a ban on certain religious practices that prevented the Quakers from worshiping. The petition signers stated that they would let everyone decide for themselves how to worship. 120 years later, the original states and the federal government specifically protected religious freedom in their constitutions. Indeed, the phrase that America's founders chose for the first individual right listed in the First Amendment, the free exercise of religion, is very important. The free exercise clause is not limited to particular exercises of religion or to the exercise of religion by certain parties, but instead protects the free exercise of religion itself. James Madison wrote in 1785 that exercising religion according to conviction and conscience is an inalienable right. 200 years later, Supreme Court Justice Arthur Goldberg declared that, quote, to the founding fathers, freedom of religion was regarded to be preeminent among fundamental rights, unquote. This belief in the special importance and preeminent status of religious freedom did not end with America's founding generation. In his famous 1941 State of the Union address, President Franklin D. Roosevelt asserted that, quote, the right of every person to worship God in his own way, unquote, is an essential human freedom. Just 4 years later, after the end of World War II, the United States signed the Universal Declaration of Human Rights. This crucial document includes religious freedom as one of the inalienable rights universal to all members of the human family. Our last several presidents have issued annual proclamations declaring January 16th Religious Freedom Day. This date marks the anniversary of the Virginia General Assembly's adoption of the Virginia Statute for Religious Freedom. In this year's proclamation, President Obama said that religious freedom is a fundamental liberty and defined religious freedom as the right of every person to live and practice their faith how they choose. In previous years, President Obama has called religious freedom a universal and natural human right and an essential part of human dignity. President George W. Bush similarly declared that no human freedom is more fundamental than the right to freely practice one's religious beliefs. And President Clinton said that religious freedom is a fundamental human right, a core value of our democracy, and essential to our dignity as human beings. I want my colleagues to appreciate how robust religious freedom has historically been in our country. Article 18 of the Universal Declaration of Human Rights states that religious freedom includes, quote, freedom either alone or in community with others and in public or private to manifest religion or belief in teaching, practice, worship, and observance, unquote. In America, religious freedom has always included freedom in both belief and behavior, in private and in public, individually and collectively. Today's attacks on religious freedom know none of this. Instead, they dismiss religious freedom as a sham, as little more than an excuse for mean-spirited people who want to discriminate. Today's opponents of religious freedom laws either do not know or do not care that religious freedom is an integral part of the origin, the identity, and the very life of our nation. They are also clearly misinformed about how, even in America, the reality of religious freedom has not always matched the promise of religious freedom. The truth is that government does many things that compromise, burden, and even prohibit the exercise of religion. The Flushing Remonstrance was necessary because community leaders allowed religious freedom for some, but not for others. Government has even sometimes passed laws explicitly designed to limit or stamp out particular religious practices or religious communities. More often, government undermines and restricts the exercise of religion through indirect impact. General laws that on their face do not explicitly target religion can nonetheless have a profound impact when applied to particular religious practices. Zoning ordinances may restrict where churches can meet, whether they may expand their meeting place, and what services they may offer. Religious institutions may be forced to hire individuals who do not share their faith, and regulations may prohibit individuals from wearing items required by their faith or require employees to work on their Sabbath. Government at all levels, federal, state, and local, is becoming ever more intrusive in virtually every facet of life. Unless government is mindful of its impact on religious practices, this means that government will become increasingly intrusive in matters of religion as well. The attack on religious freedom is also misinformed about how important religious liberty laws are to protecting the exercise of religion. Prior to 1990, more than a century, the Supreme Court's interpretation of the Free Exercise Clause had gradually moved towards broader application and stronger protection. In the 19th century, for example, the court said that the First Amendment protected religious belief, but not religious conduct, even though the First Amendment makes no such distinction. The court subsequently adopted a more unified view of religious practice and set a standard that made it difficult for government to interfere with either belief or conduct. In 1981, the Supreme Court made clear that government, quote, may justify an inroad on religious liberty by showing that it is the least restrictive means of achieving some compelling state interest, unquote. This standard was important for two reasons. First, it reflected the general importance of religious freedom in our country. Second, it applied to both religious conduct and religious belief and protected against both direct and indirect government burdens and restrictions. In a 1990 case entitled Employment Division versus Smith, the Supreme Court regrettably reversed course. Under the court's new interpretation of the First Amendment, as set forth in Smith, the Free Exercise Clause applies only when government directly burdens religion with a law targeted at religious practice. The clause provides no protection at all when government burdens religion indirectly through a generally applicable law or regulation. Before the Smith decision, it had been difficult but not impossible for government to interfere with the exercise of religion. Government had to show that a law or regulation burdening religion furthered a compelling state interest, was the least restrictive means of achieving that interest. I might add, under the court's new Smith standard, however, government can make religious practice not only difficult, but even impossible. Provided government does not specifically target religion for disfavor, it can pass all sorts of laws that interfere with worship, practice, or belief. It would be hard to overstate the impact of Smith. In 1992, the Congressional Research Service found that as a result of Smith, quote, free exercise claims have become markedly unsuccessful, unquote. Remember that the government has its biggest impact on religion not through direct suppression, but rather by indirect restriction, by disregarding religious practice as something needing special attention. Under Smith, government can do exactly what the First Amendment forbids and prohibit the free exercise of religion so long as it does so through generally applicable laws rather than laws targeted at specific groups. Congress responded to Smith by enacting the Religious Freedom Restoration Act, or RFRA. I had a lot to do with that. RFRA's standard mirrored what the Supreme Court had only a few years earlier said the First Amendment required, namely that government may impose a substantial burden on the exercise of religion only if it is the least restrictive means of achieving a compelling government purpose. RFRA does not automatically protect any specific exercise of religion, nor does it automatically prohibit any specific government action that burdens religion. RFRA sets a standard that requires balancing government action against religious freedom and puts a thumb on the scale in favor of religious freedom. RFRA leaves it to the courts in individual cases based on real facts to determine whether a particular exercise of religion or a particular governmental action is more important. In 1997, the Supreme Court held in the city of Bernie versus Flores that RFRA applies only to the federal government. This means that once again, religious practice was vulnerable to virtually any restriction, regulation, or prohibition by state or local government. States responded to the Flores decision just as Congress had responded to the Smith decision. They immediately began enacting state religious freedom restoration acts that set the same standard for state and local governments that the federal statute still imposes on the federal government. The federal statute called the Religious Freedom Restoration Act, that is. These state RFRAs differ in a few minor ways from the federal RFRA, but are identical to the federal RFRA in the core provision that really matters, the standard that government must satisfy in order to burden religious exercise. Under all of these statutes, government action that burdens religion must be the least restrictive means of achieving a compelling government purpose. I want my colleagues to understand two things about these religious freedom laws. First, states are enacting state-level religious freedom restoration acts for the same reason that Congress did. Without such laws, every exercise of religion is vulnerable to restriction or even prohibition by government. Second, state versions of RFRA operate the same way the federal statute does. They set a standard and then leave that standard for courts to apply in individual cases with real facts. In every case, the party claiming RFRA's protection must show that the government action imposes a substantial burden on his or her exercise of religion, and the government must show that this burden is the least restrictive means of furthering a compelling governmental interest. Without this protection, government action will trump religious practice in almost every case. With this protection, government action will have to accommodate religious practice in at least some cases. Those attacking religious freedom today are completely misinformed about why these laws are passed and how they work to protect religious freedom. They want people to believe that RFRA was passed to provide cover for discrimination masquerading as religious practice and to therefore oppose efforts to pass or strengthen state-level RFRAs. That account is complete fiction. RFRA was passed so that the fundamental, inalienable right to practice religion can have at least some protection. What would happen if we treated the free speech clause of the First Amendment the way these activists treat the free exercise clause of the First Amendment? No one would be protected against government restrictions on speech because a few people might say things the rest of us don't like. In addition to being misinformed about religious freedom in America and how the Religious Freedom Restoration Act protects it, The attack on religious freedom today is misguided because discrimination, not religious freedom, is the real problem. I'm sure my colleagues have heard the soundbite that RFRA legalizes discrimination. NBC News, for example, reported last year that the Arizona RFRA, quote, would have permitted businesses in the state to deny service to gays and lesbians for religious beliefs, unquote. I've explained how RFRA works to make crystal clear that this claim is false. Neither the federal government nor any state RFRA legalizes, permits, or prohibits anything. RFRA sets a standard that government must meet when its actions burden the exercise of religion. Courts apply that standard in individual cases based on real facts to decide whether the religious practice or the government action is more important. I need to make one more important distinction before looking at another reason why this claim is false. Those attacking religious freedom today use a very broad brush when raising the specter that businesses will, quote, deny service, unquote. They apparently want us to believe that businesses everywhere are intent on turning away customers on not doing business with certain people. That not only makes no sense, it just plain isn't true. Instead, the controversy exists only with regard to a few businesses that supply particular goods or services for weddings. A small number of business owners apparently feel that while they gladly serve the general public and provide goods and services to all types of customers, providing certain specific goods or services for a same-sex wedding would amount to supporting or endorsing something inconsistent with their religious beliefs. Think about what you want about those business owners. I want my colleagues to know that RFRA does not protect their decision to refuse service today. Here's what has to happen for a case pitting RFRA against a claim of discrimination to exist. The particular state where the business is located must have a law prohibiting discrimination based on sexual orientation and gender identity in places of public accommodation such as businesses. The state must also have not only a Religious Freedom Restoration Act, but one that applies between private parties. The business would have to violate the anti-discrimination law, and if the business were sued, argue that the anti-discrimination law imposed a substantial burden on the exercise of religion. Only then would a judge decide whether in that case, based on its specific facts, the anti-discrimination law or the business owner's religious beliefs were more important. Do you see why the claim that RFRA by itself legalizes discrimination is absolutely, completely false? Not only does RFRA not legalize anything, the situation in which RFRA would even be involved does not exist anywhere in America today. Right now, according to the Human Rights Campaign, 17 states have the necessary anti-discrimination law. Only 4 of those 17 have a Religious Freedom Restoration Act, and of those 4, none has a RFRA that applies to lawsuits between private parties. In other words, the number of states today in which a business could look to RFRA to justify discrimination is precisely 0. Moreover, the current controversy, misinformed and misguided as it is, has no doubt diminished the likelihood that states with anti-discrimination laws will now enact religious freedom laws. Discrimination, not religious freedom, is the real problem. Despite what the activists want everyone to believe, Americans practice religion every day in innumerable ways that have nothing whatsoever to do with anyone's sexual orientation or gender identity. In the very few situations in which religious freedom and discrimination might overlap, RFRA would actually be the way to sort out the conflict, the mechanism to balance these competing interests, and even though the exercise of religion is a fundamental and inalienable right, it is not absolute. Many courts have found that government has a compelling interest in prohibiting discrimination. Mr. President, I ask consent that an excellent analysis of this point by Attorney David Rifkin and Professor Elizabeth Price Foley that appeared in the Wall Street Journal be placed in the record following my remarks. Here's the bottom line. The situation that activists want everyone to believe is sweeping the country cannot exist anywhere in America today. And if the day ever comes when that situation does arise, many applying RFRA would place freedom from discrimination over freedom of religion by a wide margin. Mr. President, the attack on religious freedom today is not only misinformed about religious freedom in America and how laws such as RFRA protect that freedom, it is not only misguided in presenting religious freedom rather than discrimination as the real problem, and RFRA is the culprit, but it is also misleading in broadly painting religious people as mean-spirited bigots. And that's wrong, Mr. President. That's just plain wrong. And it's also unfortunate because many Americans believe in both equality and religious freedom and could be allies in seeking to maximize both. I voted for the Employment Non-Discrimination Act last Congress after working with senators on both sides of the aisle to strengthen its provisions protecting religious freedom. Earlier this year, the Utah legislature passed and Governor Gary Herbert signed a law prohibiting discrimination in employment and housing, while also protecting religious freedom. Mr. President, how did we go from religious freedom being a fundamental and inalienable right to religious freedom laws being attacked as un-American? How did we go from religious freedom being an essential human right that undergirds our nation's very existence to activists calling laws that protect religious freedom dangerous and even contemptuous? Those attacking laws that protect religious freedom would deny any legal protection for anyone to exercise religion in any way today because a few people might someday attempt to exercise their religion in a way that the courts would likely reject. This is a misinformed, misguided, and misleading campaign that will only damage religious freedom and demonize many who would work toward maximizing both equality and freedom for all Americans.